On the 14th of December 1991, a man in Phoenix, Arizona was asked to bite into a piece of styrofoam. He was 35 years old. He had served 6 years in the United States Air Force and 7 more delivering mail for the Postal Service, and he had no criminal record of any kind. He was cooperative. When the detectives asked him to come in, he came in. When they asked him questions, he answered them. And when they produced a slab of white polystyrene and asked him to close his teeth on it, he did that too, without a lawyer present, because he could not imagine what harm it could possibly do. That piece of styrofoam would cost him 10 years of his life. His name was Ray Krone, and the impression of his teeth in that foam would become the entire case against him. Not a fingerprint. Not a witness, not a confession, not a single thread of his clothing, not a hair, not a drop of blood. The state of Arizona would try him twice, convict him twice, and sentence him to death on the strength of the shape of his mouth. He had crooked teeth. That was the whole of it. This is the story of how a science that looked like science, that was taught in universities, testified to under oath, and accepted by courts across America for decades, put an innocent man on death row and left a guilty one free to hurt someone else. It is the story of the 10 years it took to undo. And when the truth finally arrived, it did not come from a detective or a judge or a re-examination of the evidence. It came from a machine comparing one string of letters to another in a database that had not existed when Ray Krone was arrested. And it is the story of where the real killer had been, all that time while a postal worker sat in a cell waiting to be executed for what he had done. To understand how this happened, you have to understand what the police were looking at on the morning of the 29th of December, 1991, and how little they had. A woman named Kim Ancona had been killed overnight in a bar called the CBS Lounge on East Camelback Road in Phoenix. She was 36. She worked there as a bartender, and she had been closing up alone. Whoever killed her had left almost nothing behind. There were no useful fingerprints. There was no murder weapon recovered at the scene. There was no sign of forced entry, which suggested she had either known the person or let them in after hours. And there were no witnesses, because at that hour there was nobody left in the building to witness anything. The first days of an investigation like that are a particular kind of pressure. A bar is one of the worst possible crime scenes. Hundreds of people pass through it in a week. Every surface has been touched by dozens of hands, and the physical traces of any one of them are buried under the traces of all the others. Detectives working the CBS Lounge were not short of material. They were drowning in it, and almost none of it meant anything. What there was on her body was a set of marks. The medical examiner recorded them as bite marks. There were 2, one on the left breast, one on the neck. In a case with no fingerprints, no weapon, and no witness, those marks were the only thing that might be said to carry a signature. And in 1991, in Phoenix, Arizona, a bite mark was considered to be exactly that. So the question became simple: who had teeth that matched? Before we go further, you need to know why the detectives in that room believed a bite mark could answer that question at all. Because they were not being reckless. They were applying what the American legal system had spent nearly 2 decades telling them was true. The technique had entered American courts properly in 1975 in a California case called People versus Marx. An elderly woman had been killed, and there were bite marks on her nose. 3 dental experts compared them to a suspect's teeth using dental models and photographic overlays. The court admitted the testimony, and the conviction was upheld on appeal. The appellate ruling was cautious. It noted the unusual clarity of these particular marks, but the door was open, and precedent works the way precedent works. Once one court has admitted a technique, the next court is no longer evaluating a novel claim. It is following authority. And then, 4 years later, bite mark evidence got something no forensic discipline can buy: a famous conviction. In 1979, in Florida, Ted Bundy was tried for the murders at the Chi Omega sorority house in Tallahassee. The physical evidence against him was thin. What the prosecution had was a bite mark on one of the victims, and Bundy's teeth, which were crooked and chipped in a distinctive way. A forensic odontologist named Richard Suverin testified that the marks matched. The jury convicted, and Bundy was sentenced to death. That case did more for bite mark analysis than any study could have. It put the discipline on the front page of every newspaper in the country, attached to the most notorious criminal of the era, in a trial that ended in conviction. It established forensic odontology in the public mind and in the professional one as a technique that caught monsters. Prosecutors saw a tool that worked. Dentists saw a career path. Juries saw a science that had helped convict Ted Bundy and reasoned, sensibly and wrongly, that it must therefore be sound. Nothing about the Bundy verdict demonstrated that bite marks could reliably identify a person. It demonstrated that a jury would convict on them. Those are entirely different propositions, and for the next 20 years, almost nobody in the system distinguished between the two. By 1991, the American Board of Forensic Odontology had been certifying practitioners for 15 years. There were conferences, credentials, and expert witnesses available in every state. When the Phoenix detectives looked at the marks on Kim Ancona's body, they were not reaching for something experimental. They were reaching for an established tool. A friend of Kim Ancona's told police that she had mentioned a man named Ray who was going to help her close the bar that night. Krone was a regular. He played on the bar's darts team. He knew her the way a regular knows a bartender. Well enough to be named, not well enough to be close. He was, by his own account and everybody else's, one of perhaps dozens of people who drank in that bar and knew Kim Ancona by name. But he was the Ray who had been mentioned. And when the police brought him in and looked at him, they saw something that must have felt like providence. Ray Krone's front teeth were noticeably crooked. The upper incisors were rotated and misaligned, one pushed forward over the other in a way that was immediately visible when he spoke. It was the kind of dental irregularity a person notices about themselves in photographs and stops thinking about by the time they are 20. It was also, in the logic of forensic odontology, as it was practiced in 1991, a signature, a unique and identifiable pattern that would leave a unique and identifiable mark. They asked him to bite the styrofoam. He bit it. He was arrested and charged with murder within days. And from that point on, the state of Arizona had a theory, and everything that followed was built on it. Here is what you need to understand about bite mark analysis, because it is the thing that makes this case matter beyond one man's misfortune. It was never tested, not in the way you would assume. The premises seemed reasonable, and that was the problem. They seemed so reasonable that nobody insisted on checking them. The first premise was that human dentition is unique, like a fingerprint, that no two people in the world have exactly the same arrangement of teeth. The second was that this uniqueness transfers faithfully to skin, that when teeth close on a human body, they leave a mark preserving that individuality accurately enough to identify one person and exclude everyone else. Both of those premises were assumed. Neither had been established by the kind of study that would be required of a new drug or a new engineering material or any claim in a working laboratory science. There was no known error rate. There was no database of dental patterns against which uniqueness could be measured. There was no standard method that different examiners were required to follow, and no test of whether two qualified examiners looking at the same mark would even reach the same conclusion. And the second premise, in particular, was worse than untested. It was working against physics. Skin is not a recording medium. It is elastic. It moves, it swells, it bruises, and it changes over hours and days. A mark made on a living body is distorted by the body's own response to being marked. A mark on a body that has been moved or that has lain in one position for hours distorts further. The tissue that receives a bite is not a fixed surface like wax or clay. It is close to the least reliable substrate you could choose for recording a fine pattern. There is a further problem, and it is the one that would eventually prove fatal to the whole discipline. Bite mark analysis was not conducted blind. The examiner was typically given the mark and the suspect's dental impression together, already knowing that the police believed this person had done it. They were not asked an open question, whose teeth made this mark? They were asked a closed one. Could these teeth have made this mark? And a closed question asked of an ambiguous pattern by someone who already knows the answer the asker is hoping for has a strong tendency to come back yes. None of this was hidden. It was simply not asked. What existed instead was a professional community with credentials, conferences, a certification process, and a body of experts who testified in criminal trials across the country. It had the apparatus of a science. It had the vocabulary of a science. What it did not have was evidence that the thing it claimed to do could actually be done. And juries, being reasonable people, heard a credentialed expert say that the marks on a murdered woman's body matched the defendant's teeth, and they did what reasonable people do. They believed it. Ray Krone's first trial began in August 1992. The prosecution's case had a hole in the middle of it that would be obvious to anyone reading the file today. There was no physical evidence connecting Krone to the crime scene beyond the bite marks. Blood was found at the scene that did not belong to Kim Ancona and did not belong to Ray Krone either. Hair recovered from the scene did not match him. A palm print did not match him. He said he had been at home, asleep, and there was nothing to place him at the bar that night beyond a friend's recollection that Kim had mentioned a man named Ray. Against that, the state had a videotape. The prosecution's expert, a dentist named Raymond Rawson, had prepared a video presentation demonstrating how Krone's dental impression overlaid the marks on the victim's body. It was shown to the jury. It was persuasive in the way visual demonstrations are persuasive. It took an abstract claim and made it look like a physical fit, a key going into a lock. Rawson testified that the marks matched Krone's teeth. There was also a problem with the tape that would matter enormously later. The defense had been given almost no time to review it before trial. Their own expert had not had the opportunity to examine it properly. In a case where a single piece of evidence carried the entire prosecution, the defense went into court without having been able to test the only thing that mattered. The jury convicted him. He was sentenced to death. The press at the time gave him a nickname. They called him the Snaggletooth Killer. It was printed in newspapers. It followed him. A man was going to be executed, and the thing the public knew him by was the shape of his teeth. He went to death row at Arizona State Prison and began the process of appeal, which in a capital case is slow, expensive, and almost always futile. It is worth being clear about what an appeal can and cannot do, because most people assume it is a second look at whether the defendant did it. It is not. An appeal examines whether the trial was conducted correctly, whether evidence was properly admitted, whether the judge instructed the jury correctly, whether procedure was followed. It does not reweigh the facts. An appellate court reading Ray Krone's file was not asking whether the bite marks really matched. It was asking whether the trial court had been entitled to let a jury hear a qualified expert say that they did. And under the law as it stood, it plainly had been. That distinction is the trapdoor underneath every conviction built on bad forensic science. If the science is admitted correctly and the expert is credentialed and the procedure is followed, then the appeal has nothing to bite on. The system's error correction machinery is designed to catch procedural failures, and this was not a procedural failure. Everybody followed the rules. The rules permitted a technique that did not work. But in 1995, something unusual happened. The Arizona Supreme Court overturned his conviction. They did not do it because they doubted the bite mark evidence. They did it on a procedural point. The state had failed to disclose that videotape to the defense in time, and that failure had deprived Krone of a fair opportunity to challenge the central evidence against him. It was a narrow ruling about disclosure, not a judgment about the science, which meant the state got to try him again, and the science got to walk back into the courtroom untouched. The second trial in 1996 went worse. By now, the defense had experts of their own prepared to say that the bite mark identification was unsound. They put on that case. It did not work. The problem was structural, and it is worth being precise about it, because it explains why bad forensic science is so extraordinarily difficult to dislodge once it has been admitted. When a defense expert stands up and says the state's analysis is wrong, a jury does not hear a scientific claim being refuted. It hears two experts disagreeing. And when two experts disagree, a jury falls back on the things it can actually assess. Which one seemed more confident? Which one seemed more credentialed? Which one was hired by the side that appears to be making excuses? The state's expert is presented as neutral, an officer of the system. The defense's expert has been paid by the accused. The asymmetry is invisible in the transcript and decisive in the jury room. He was convicted a second time. This time the judge did something that turned out to matter. He sentenced Krone not to death, but to life imprisonment. And in doing so, he said on the record that he had reservations. He stated that he was not entirely convinced of Krone's guilt, and that the doubt was sufficient that he was unwilling to impose a death sentence. Read that again, because it is one of the strangest sentences in American criminal justice. A judge said in open court that he was not sure the man in front of him had done it, and then sent him to prison for the rest of his life anyway, because within the rules as they stood, that was the outcome the verdict required. Ray Krone went back to prison. He had now been convicted twice by 2 juries on the same evidence. In the ordinary run of things, that is the end. 2 convictions is the point at which the system considers the matter closed, and the appeals become a formality that runs out. It is worth pausing on what those years actually were, because the phrase 10 years in prison passes very quickly in a sentence and did not pass quickly for him. He spent the first stretch on death row, which in practice means near total isolation. A cell, meals through a slot, limited time outside it, and the specific psychological weight of a scheduled ending. He was a man with no criminal history at all, an Air Force veteran, a postal worker with a clean record, dropped into the most restrictive environment the state operates. He maintained throughout that he had not done it. Prisoners who maintain innocence are, as a rule, treated worse by the system than those who express remorse, because remorse is what parole boards and programs are built to reward. Refusing to confess to something you did not do carries a price, and it is paid in years. His family kept working. That is the unglamorous engine underneath most exonerations. Somebody on the outside who does not stop. They spent money they did not have on lawyers and experts. His parents remortgaged. A cousin campaigned. None of it produced a breakthrough for a decade. What saved him, in the end, was not a lawyer or a judge or a re-examination of the bite marks. What saved him was that somebody had kept the evidence. Throughout both trials, biological material recovered from the scene and from Kim Ancona's clothing had sat in storage. It had been tested using the methods available in 1991 and 1992, and those methods had not been sensitive enough to produce anything conclusive. The samples were small. The technology of the early 90s needed a relatively large, relatively clean sample to produce a usable profile. But the samples had not been destroyed. They had been preserved, catalogued, and left in an evidence locker, and they sat there through the first trial, through the appeal, through the second trial, and through the years afterwards. And while they sat there, the technology changed underneath them. Through the 1990s, DNA analysis moved from a technique that needed a substantial sample to one that could work from traces, from a few cells, from material that a decade earlier would have been dismissed as insufficient. What had been untestable in 1992 was routine by 2001. In 2002, Krone's legal team secured an order for the preserved samples to be retested using current methods. The results came back that April. DNA from saliva on the victim's clothing and from other material recovered at the scene produced a clear profile. It was not Ray Krone's. That result did 2 things at once, and it is worth separating them, because they are not the same thing, and the second is what makes this case extraordinary. The first is that it excluded him. The DNA proved that the biological material left by the person who killed Kim Ancona did not come from Ray Krone. After 10 years, 3 months, and 8 days in prison, much of it under sentence of death, he was exonerated and released. He walked out in April 2002 as the 100th person in the United States to be exonerated from death row since capital punishment was reinstated in 1976. The 100th, not the first, not an aberration, the 100th. The second thing the DNA did was answer the question the bite marks had been brought in to answer. Because by 2002, there was a national database. The Combined DNA Index System, CODIS, had been collecting profiles from convicted offenders across the United States since the mid-1990s. The profile recovered from Kim Ancona's clothing was run against it. It matched a man named Kenneth Phillips. Phillips had been living, at the time of the murder, roughly 600 yards from the CBS lounge. He had no connection to Ray Krone. He had not been a suspect. He had never been interviewed because the investigation had found its man in the first week and stopped looking. And here is the part that sits worst. Kenneth Phillips was already in the custody of the state of Arizona. He was serving a sentence for a violent assault committed a matter of weeks after Kim Ancona was killed, in the period when the police had already arrested Ray Krone and considered the case closed. The man whose teeth did not match had spent 10 years in prison. The man whose DNA did match had been inside the same prison system for most of it, convicted of a crime he committed while an innocent man was being processed for his. Phillips was subsequently convicted of Kim Ancona's murder. Stay with that sequence for a moment, because it contains the part of this story that usually gets lost. A wrongful conviction is normally discussed as a harm to the person convicted, and it plainly is. But it is not only that. Every wrongful conviction has a second half, and the second half is that the investigation stops. The file closes. The detectives move to other work. Whoever actually did it walks out of the frame entirely, not because they were clever, but because the system has stopped looking for them and formally announced that it has found them already. In this case, the timeline is unusually stark. Kim Ancona was killed in late December 1991. Ray Krone was arrested within days. And within weeks of that arrest, with the case considered solved, with the police no longer searching, with the entire apparatus of the Phoenix investigation now pointed at building a prosecution against a postal worker, the man who had actually killed her committed a violent assault on somebody else. That is not hindsight, it is arithmetic. There was a window in which the real perpetrator was at liberty and unexamined, and the reason the window existed was that the wrong man had already been arrested. So the bite mark evidence did not simply take 10 years from Ray Krone. It closed a live murder investigation on a false answer, and it did so quickly enough that the consequences fell on a real person who did not have to be harmed. Kim Ancona's case was not solved in 1992. It was only declared solved. The difference between those two things had a cost, and somebody else paid part of it. Ray Krone came out in 2002 at the age of 45. He had gone in at 35. He received compensation from the state and the city. The figure eventually reported was around $1.4 million, a little under $140,000 for each year taken. He has spent the years since speaking publicly about wrongful conviction and about the science that produced his. Because the science did not quietly retire after this. That is the thing worth staying with. Ray Krone was not the only one, and his case was not the worst. Consider what else was sitting in American prisons while the discipline continued to operate. In Mississippi, 2 men from the same small county were convicted in separate cases in the early 1990s, each on bite mark testimony from the same forensic dentist. Levon Brooks was convicted in 1992 and given life. Kennedy Brewer was convicted in 1995 and sentenced to death. The marks on the victims were identified as human bites and matched to each man's teeth. Both convictions stood for years. Both were eventually overturned by DNA, and when the DNA was run, it identified a single man who had committed both crimes, someone who had been a suspect early on and was not pursued. 2 innocent men, 30-plus combined years, 1 actual perpetrator free the entire time, and in at least one instance, a serious question about whether the marks were bites at all, rather than damage from insects and small animals. In Virginia, a sailor named Keith Harwood was convicted in 1982 after 6 dental experts testified that his teeth matched marks on a victim. He served 33 years. DNA cleared him in 2016 and identified another man who had died in prison in 2006 while Harwood was still serving. In Texas, Stephen Mark Cheney was convicted in 1987 on testimony that the odds of the bite mark coming from someone other than him were 1 in a million. That statistic had no basis whatsoever. There was no data set from which such a figure could be calculated. He served 28 years. Read those together, and a pattern emerges that is not about individual error. The same technique, in different states, with different examiners, produced the same result. Confident identification of the wrong man, surviving trial, surviving appeal, and undone only by a biological test that had nothing to do with teeth. It took until 2009 for for the National Academy of Sciences to publish a landmark report examining forensic science in the United States, which found insufficient scientific basis to conclude that bite marks could reliably identify an individual. It took until 2016 for the President's Council of Advisors on Science and Technology to review the discipline again and conclude that it did not meet the standards of a valid method, and to note that examiners could not reliably agree even on whether a given mark was a human bite at all. 25 years after Ray Krone bit into a piece of styrofoam in a Phoenix police station, the highest scientific advisory bodies in the country were still writing reports explaining that the thing which convicted him had never worked. And almost nothing happened to the people who provided the testimony. Expert witnesses are generally immune from civil liability for what they say on the stand. Professional bodies police their own members, and a body whose existence depends on the legitimacy of a technique has limited appetite for concluding that the technique is worthless. Some practitioners faced professional consequences, most did not. The men who went to prison were released, in the cases where they were released at all, and the structure that put them there remained standing. You would assume that after 2 national scientific reviews reached that conclusion, the technique would simply have been withdrawn. It was not, and the reason is worth understanding, because it is the same reason it took so long to expose. Courts do not work like laboratories. A laboratory abandons a method when the evidence against it becomes strong enough. A court asks a narrower question. Is this the kind of evidence that judges in this jurisdiction have previously allowed juries to hear? And by 2009, the answer had been yes for 34 years, in state after state, in hundreds of cases. The weight of precedent was enormous, and precedent does not care what the National Academy of Sciences has published. Every judge who admitted bite mark testimony after 2009 could point to a long line of judges who had admitted it before. There was movement. In 2016, the Texas Forensic Science Commission, which had been examining the Cheney case, recommended that bite mark comparison should not be admitted in Texas courtrooms without demonstrated scientific validity, the first body of its kind in America to take that step. Some appellate courts elsewhere began to treat the testimony more skeptically. A number of practitioners left the field. But there was no national moment of withdrawal, no order that vacated the convictions built on it. What happened instead is what usually happens. The technique faded slowly at the front end, becoming harder to introduce in new trials, while the people already convicted on it stayed exactly where they were. A discredited method does not release anybody. Somebody has to bring each case back, one at a time, with lawyers and funding and preserved evidence, and a court willing to look again. And most of those cases have no preserved evidence at all, because in the great majority of crimes, there is nothing biological to retest. That is the quiet arithmetic underneath every exoneration you have ever read about. Ray Krone got out because his case happened to have a saliva sample. The men whose cases did not are still serving. There is a way of telling this story that makes it about a mistake, and that telling is comfortable and wrong. A mistake is a fingerprint misread, a witness who saw badly, a lab result mixed up. Those things happen, and systems are built to catch them. This was not that. The bite mark evidence in Ray Krone's case was not misapplied. It was applied exactly as the discipline intended, by a certified practitioner using accepted methods, and it produced a confident identification of an innocent man. The technique worked as designed. The design was the problem. And the mechanism that eventually corrected it was not the courts, and not the profession, and not any process of scientific self-examination. 2 juries heard the evidence and believed it. 2 trials tested it under adversarial conditions, and it survived both. A judge who doubted the verdict imposed it anyway. The correction came from outside, from a preserved sample, a technology that improved while the case sat still, and a database that did not exist when the case began. Ray Krone was not freed because the system realized it was wrong. He was freed because somebody, years earlier, had put a swab in an envelope and not thrown it away. That is a thin thread to hang a man's life on. And it is worth asking, as the cases built the same way continue to be reviewed one at a time, how many other envelopes were never kept?